Family home should no longer be treated automatically as relationship property to be split 50-50 in the event of a breakup. That's the view of the Law Commission, which has released its final report today, following its review of the Property Relationships Act. Barrister Vivienne Crawshaw specialises in family law with a focus on relationship property matters. She says of the many recommendations the report makes, the public will notice four main things.
One is the changes to the family home. Two is future family income sharing awards, so no economic disparity payments. 3, trusts and how they impact on relationship property. So that's a big change. And 4 is the court's role in considering the children's needs in the division of relationship property. So that's a big change too.
Okay, maybe we can just go first, because what's been changed first of all is a break of the clean break principle. That's where the partners split up and immediately the house is divided between the two 50-50. What we're looking at now, and correct me if I'm wrong, is that only property that has increased in value since the couple has been together, even in a de facto relationship that's been there for more than 3 years, only that increase in value will be split 50-50. That's pretty much been confirmed.
Yeah, so that's the change to the family home. That's not so much the clean break principle. And remember, the clean break principle is something that people have talked about and judges have talked about, but it's actually not in the legislation. So the family home change is significant, because I think really since the 1970s, most New Zealanders have got their head around the fact that if you live with someone or you're married with someone and it's more than a short duration relationship, you're going to have to share that family home equally, no matter how it was acquired, who bought it, whether it was inherited from great aunt Ethel or what. The change, primarily, as you've said, is going to be that actually that is not going to be shared equally. And in fact, if you've brought that home to the relationship, that is not going to suddenly become relationship property, because the focus is going to be on the family joint venture, as in what the couple do together, as opposed to the use concept, which is family use then makes the asset relationship property. So that's a big change.
So what do you see as the major changes here, and particularly for the uninitiated, what's there to look out for?
Well, one of the big changes is with trusts, because at the moment somebody might be able to set up a trust or settle property on a trust during a relationship or with the purposes of avoiding sharing relationship property. And it's a bit of a devil to be able to claw back that property. So it's like a contracting out agreement with one hand clapping. With contracting out agreements, you both have to have independent advice. If you settle property on a trust, you don't, and one person can go off and do that. Now, there are ways of protecting the disadvantaged party, but it's not easy. It's not straightforward. And there are 2 different statutory means of doing that, one under the Property Relationships Act and one other under another statute, and it's complex. So the Law Commission is suggesting some much more broad, bold ways of dealing with trusts that are set up and property settled on those trusts during the relationship. And I think that's quite a positive move. That really keeps us in line with other Western and Commonwealth countries.
What about dealing with prenuptial agreements? There's a lot of debate about whether there should be more awareness about those, whether couples should be getting into them beforehand. In this proposal, will those prenuptial agreements trump what's in the Act, or will it be the other way around?
Well, there will still be a means of setting aside prenuptial agreements or contracting out agreements if there's to do that is to cause serious injustice. What's being proposed here under this new proposal of the Law Commission is that if the court considers that parts of the agreement are unjust, they can set aside parts of the agreement rather than the entirety of the agreement. That's kind of a pretty positive change. One thing that concerns me and many others is that there will now be an ability to contract out of the future income sharing arrangements that I can talk to in a minute. And that's problematic because when a couple enter a relationship and they're both financially independent, it's quite hard to imagine what it might be like to have triplets or, at least some children that have really negatively impacted on your career prospects. And if you've contracted out of those provisions, that could really result in an agreement being quite unjust on a separation where one person's completely left out of the cold financially. Because remember, what they're also proposing is doing away with spousal maintenance. So at the moment you can't contract out of spousal maintenance, but you are going to be able to contract out of this family income sharing arrangement.
Criticism in the past has been that there's an attitude that the couple will do everything in the best interests of the children. These changes have been spruiked as doing more things in the interests of children. There's been calls by the Children's Commissioner, Andrew Beckcroft, to look at that as well. What's the detail there? Yeah,
so this is significant. We've already got a provision in our Act where the interests of children is a consideration, but it just hasn't happened. So what the Law Commission is suggesting is that the children's interests be an overarching consideration in the division of property. That is a significant change, so it'll be an overarching obligation on the courts to have regard to the best interests of any minor or dependent children. And the way the Commission have framed this is that there will be a sort of fundamental obligation to ensure that there is an occupation order of, say, the family home or what was the home that the parties lived in to provide the children with a home. And that's that is actually a broader provision than we have currently, and it's not used as much as it could be. So that will be quite a change, and so perhaps that might ameliorate the kind of harsher consequences of the changes to the family home. So, I mean, the Commission has emphasised this as a package of reforms, and certainly is, if you took one out and left others, it would become unbalanced.
That's Barrister Vivienne Crawshaw on those proposed changes to the Property Relationships Act.